Good evening, ladies and gentlemen. Suzanne Dibble here, data protection law expert, coming to you raw and uncut. And oh, how I have missed doing these videos. But true to form, it's nearly 1 o'clock in the morning, having just been out for date night with my husband. But I promised to do a video on the new, the preliminary ruling in the German courts about the German company that refused to take down its Facebook fan page. And this has been trundling on for several years. And a few days ago, there was this preliminary ruling that effectively a fan page administrator is a controller, a data controller. Facebook is absolutely a data controller, but it would seem, according to the German courts at least, that a Facebook fan page administrator is also a controller. So let's have a look at the detail of that and the likely consequences for people who have Facebook fan pages. So how did this all start? Well, I've been trying to dig into it, and it's a little light on facts, because how did this poor company get embroiled in this? I can't find anything on the internet about it, but I would imagine that according to the facts of the case, nearly every company in the EU would be in a similar position, and yet this poor company was the one that was chosen. And it was several years ago, it's 2011, and the one of the German data protection authorities, they seem to do it on a more regional basis. In 2011, the ULD, which is the supervisory authority for the land of, I'm not even going to try to pronounce this, well actually I will, Schleswig-Holstein in Germany, ordered this company, which is an education company, Wirtschaftsakademie, to deactivate their fan page on pain of penalty payment if it failed to comply within the prescribed period, on the grounds that neither this company, German company, nor Facebook informed visitors to the fan page that Facebook, by means of cookies, collected personal data concerning them. But then the German company brought a complaint against that decision. So rather than just shutting down their fan page and going on about their business, they brought a complaint against the decision, essentially saying that it was not responsible for the processing of the data by Facebook or the cookies that Facebook installed. Now, this went backwards and forwards in the German courts. Well, it still is, for several years. And certainly the early decisions were that, of course, a Facebook fan page administrator is not a controller. However, the decision of 2 days ago, or 3 days ago, whenever it was, it's not the final decision, firstly. That's one point. It's a step in the action pending before the National Court. So basically, I think this specialist court has been asked to opine on certain questions, which it has done, but it's not giving any kind of judgment about what the German company has to do or anything like that. That will still trundle on. So what was the question that we're interested in that it put to this particular court for a preliminary ruling was, the questions that were asked were, does a trying to pick out the salient bits here without reading the whole lot because it's quite complex. Is there a responsibility for an entity that does not control the data processing when it chooses the operator of its information offering? So I read that as saying, if you are not a data controller but you choose the operator, then is there a responsibility there? I.e., should they have had a fan page at all if Facebook wasn't compliant with data protection legislation? Because at this point in time, the reason that this all came about, Facebook was not complying with data protection legislation. It wasn't informing users that it was using cookies and informing them how their data was being processed. And then the second question was that does it follow on from that the controller must choose a processor providing sufficient guarantees in respect of the technical security measures, and that where there are other user relationships not linked to data processing on the control... got a bit of a mosquito buzzing around me, that's pleasant. Go away. Right, let me start again with that. So, does it follow that where data processing is carried out on the controller's behalf, that the controller must choose a processor providing sufficient guarantees in respect of the technical security measures and organisational measures governing the processing to be carried out, that where there are other user relationships not linked to data processing on the controller's behalf, there is no obligation to make careful selection, and no such obligation can be based on national law. So those questions to me are really asking about the responsibility of using processors, using, when it's choosing the operator of its information offering, i.e., is there a responsibility on the German company to have verified before it used Facebook that Facebook was actually compliant? That's how I read those questions. However, then what the court actually decides to talk about is whether the German company is and therefore any Facebook page administrator, whether that German company is a controller or not. It says that the directive defines the concept of controller broadly. Now, it's important to note that this, because this has been trundling on for several years, this is based on not on the GDPR, but the directive that came before GDPR. However, the definition of controller is pretty much the same in both directives. So, in both the directive and GDPR. So, so I think that, certainly this does, apply to GDPR insofar as the definition is the same. So, so it says the old directive defines the concept of controller broadly, and the objective is to ensure, through a broad definition of the concept of controller, effective and complete protection of the persons concerned. This concept does not necessarily refer to a single entity, blah, blah. So this is the full judgment, not just the press release that I've looked at here. But what they go through what a Facebook fan page administrator does compared to Facebook, and it starts off by saying Facebook must be regarded as primarily determining the purposes and means of processing. So, of course, there's no argument that Facebook is absolutely the controller, and that wasn't the issue here at all. Facebook is definitely the controller. But then it goes on to say that I just want to pick out the relevant bits. Yeah, so the creation of a fan page on Facebook involves the definition of parameters by the administrator, depending on the target audience, the objectives of managing and promoting its activities, which has an influence on the processing of personal data for the purpose of producing statistics based on visits to the fan page. The administrator may, with the help of filters made available by Facebook, define the criteria in accordance with which statistics are to be drawn up, and even designate categories of persons whose personal data is to be made use of by Facebook. Consequently, the administrator of a fan page hosted on Facebook contributes to the processing of the personal data of visitors to its page. So that's the key paragraph that this particular court seemed to think means that the administrator of a Facebook fan page is also a controller. Now, the key point for me is that towards the end of the answering of that question, the judgment states that However, it should be pointed out that the existence of joint responsibility does not necessarily imply equal responsibility of the various operators involved in the processing of personal data. On the contrary, those operators may be involved at different stages of that processing of personal data and to different degrees, so that the level of responsibility of each of them must be assessed with regard to all the relevant circumstances of the particular case. Now, what on earth does that mean? How are we supposed to... Okay, so if we are joint controllers in some way with Facebook, what's my responsibility and what's Facebook's responsibility? We don't know. They haven't said. The level of responsibility of each of them must be assessed with regard to all the relevant circumstances of the particular case. So that doesn't really give you much to go on, does it? I just wanted to pick out some other bits as well. So I think in terms of practical... So the first thing that I just want to stress is that this is not a definitive ruling, okay? This was just questions answered as part of a process, okay, number one. Number two, actually quite a bit of the previous judgments and the way that the case has progressed is based on German law. So that is obviously something else to think about. The German data protection authorities are notoriously, they are a strict authority. Certainly the ICO in the UK and the Irish Data Protection Commissioner are much more typically lenient, not lenient, but they will have a softer interpretation. I think this is a very draconian interpretation. So that's the first thing. It's not done and dusted. Now, what is the practical consequence? Well, actually, before we get into that, I just want to read out a statement that I found from the Data Protection Commissioner of Schleswig-Holstein, Marit Henson. He welcomed the judgment of the ECJ. The judgment confirms my view that there must not be gaps in responsibility under data protection law. This means specifically that all administrators of Facebook pages have to ensure that they and Facebook conform to their respective obligations under data protection law. It must be clear who carries out these obligations vis-a-vis Facebook page visitors. This is particularly important with regard to the information obligations, i.e., giving them the privacy policy and telling them what you're going to be doing with their data. Transparency is required for the processing of data concerning all users, whether they are members of Facebook or non-members. Any data subject can exercise the data subject rights, for instance, the right to access or rectification, and demand that both Facebook and the Facebook administrator conform to these. Okay, so what that certainly seems to be saying is that if a data subject exercised the right to access or rectification, then if something is wrong within personal data that's being processed on that fan page, then as an administrator we would have to take steps to resolve that. And I think that's what we'd do anyway, isn't it, really? If someone says there's some data that's wrong about me on your Facebook page, then the reasonable response would be to go and actually rectify that. And right to access, well, what insofar as that Facebook page is concerned, what won't they be able to access that they can't already see? I'm not entirely sure that I understand that. And then the judgment actually picked up on the fact that, which I don't entirely understand, I have to say, I'll have to speak to Veronica about it tomorrow, but it did pick up on the fact that, I can't find the bit now, but picked up on the fact that you don't have to be a member of Facebook for the cookies to have been triggered effectively. If it's sufficient to go on the home page, it says, for the relevant cookies to be triggered. And so I imagine in my simple non-technical mind that what that means is that maybe the German company on their own website had a link to their Facebook fan page, and that people who went onto that page were somehow tracked, even though they weren't actually members of Facebook, because I can't actually think how otherwise people could actually land on that Facebook fan page if they weren't members of Facebook. Please do comment in the comments below if I've totally misinterpreted that. I am not a techie person at all, so please do put me right on that. But really, the questions that it's raising to me are who is responsible for the privacy policy at the point where data is being processed. Certainly for me, it should be Facebook. Quite frankly, at the point that the person signs up for Facebook, then Facebook should be the one that says, here's the privacy policy, not us. Now, if it is the case, and I'm right that the fact that they were getting quite excited about the fact that this also affected non-members of Facebook, then maybe, and I can't find out more about it from my internet research at least, maybe it was the fact that they were also looking at cookies on the website of the German company, and they didn't have a privacy policy or a cookie policy on that site. Anyway, I think the upshot is it underlines the importance of having a privacy policy and a cookie policy both on your website, but also, we'll need to think about whether we need to be putting privacy policies on our Facebook pages. However, arguably that's too late, because by that point, presumably, the cookies have already fired, and certainly if you're, it's at the point of, and plus it's at the point of that's the point, is it is at the point of collecting the data. So if you're collecting personal data through the use of cookies, then arguably that is too late to put in, maybe a pinned post or whatever the equivalent is in a fan page, to have your privacy policy there. Anyway, I don't think it can harm matters if you do. So if you have a fan page, and indeed I do, not that I personally actually do much with it, I think that we should, in what is the equivalent of the pinned post, we should be putting in a link to our privacy policy and our cookie policy, and maybe even also to Facebook's privacy policy and cookie policy. So, and then, we need to bear in mind, like I just read out the statement there of the Data Protection Commissioner of Schleswig-Holstein, we need to think about data subject rights. So if people approach us as the Facebook administrators, the page administrators, and say, I want to exercise my right to be forgotten, then presumably this means potentially that we would be data controllers in that sense, and we would need to go through that fan page and delete all references, all personal data related to that person. So I don't think this is as worrying a judgment as people are making out. I think that it certainly raises questions about the interrelationship in responsibility between the us as users, business users of Facebook, shall we say, and Facebook itself. And I think that will be clarified over the coming months and years. So it'll certainly be interesting to see the progression of this case and what actually happens. So I'll keep on top of that and update this group on that. I think really that the way that it would have been better to approach this is to say, indeed, I think it's the way that the questions were leading the discussion, is to say, okay, is the German company at fault by using a data processor, or by using a platform that isn't, or that wasn't at that time compliant? I think that's a better question to ask myself, but there you go. But we'll see the outcome of this case. I think in the meantime, if you've got a Facebook fan page, don't panic. I would be making sure that you've got a privacy policy and a cookie policy on your website. Also think about putting one on your fan page. and also possibly a link to Facebook's own cookie policy and privacy policy. And yeah, I think that's all I can say for now. So I'll keep a watching brief on this, a really interesting case. And if you've got any comments about any of that, then do feel free to post below. And don't forget, if you haven't yet got your privacy policy and your cookie policy, they are just 2 of the documents that are in my GDPR pack. Details are in the pinned post to this group. So if you haven't yet got that, then do go and check that out. And do remember also that I'm doing, if you've bought the pack, I'm doing a live Q&A on Mondays that will help you with any questions you have on the pack and the implementation of that. And also I'm doing a general Q&A for anybody in the group on Fridays. Saying that, this Friday I've got to take my mum to the hospital. Nothing serious, just consultation. But it was serious because she was in intensive care not long ago. So hence I'm going to go with her and ask the right questions, because I don't know about you, but with my parents, they go to the doctors and they come back and you say, well, did you ask them this? Did you ask them that? And no. And what did they say about this? Oh, can't remember. So hence I'm going to go with her. So I think I'm going to change the time of the Q&A on Friday to slightly later, but I'll keep you updated on that. So I'd say any comments on this case, it's an interesting one. I don't think that we necessarily need to panic, but there's a few sensible steps that we can take to protect ourselves until we get more clarity on this. So good night for now, and I will see you very soon.